Navigate the journey to becoming a great lawyer with expert guidance on topics that range from trial skills to corner office management. Here you will learn how to tap into your potential for legal greatness. I'm Andrew Smiley, and this is The Mentor, ESQ.
Today is going to be fun, a lot more fun than yesterday. So thanks for coming back. And today we're going to talk about a couple different things. But primarily, the first hour is going to be about deposition and discovery basics. And the second and third hour is going to be about trial skills. We're going to go through lots of great stuff, so you will all feel fully prepared to rock and roll with your depositions. And if you get thrown into a trial at the last minute, at least you'll have some information and know what you're doing. It's perfect timing that we're starting off with depositions and discovery basics, because I literally just came from a deposition 2 minutes ago. But with the technology these days, it's great. I could go right from a deposition. It was a multi-party. I was one of multiple people questioning, and I was literally looking at the clock waiting for someone to finish, and I jumped in, and it was one of these very contentious with the type of lawyer who I'm going to tell you about and how best to deal with these types of lawyers when you encounter them in depositions. He was very obstructive. He was smirking under his breath. He was talking to his client while I was asking questions, all things that are just not appropriate. And sometimes you got to drop the hammer on them. And it actually got to the point that when I was going to hop off to come here, everybody at my suggestion was going to contact the judge and ask the judge to assign a monitor to sit in on the Zoom deposition to keep this guy in check, because it was just crazy. So I've got to take a deep breath. I'm a little fired up from what I just came from, folks. So
good. You want to be fired up
with me. We're fired up here. All right. We're going to keep you awake. From 1 to 4, it's going to go fast, faster than yesterday, and hopefully some really good stuff. If you remember the ground rules from yesterday, I'll reiterate them. Please put your questions, comments, thoughts, everything in the Q&A. We love getting that stuff from you. And Sally and I will check those throughout the presentation and try and address those that we can during the presentation. But we'll also save 10 minutes or so at the end of each hour to go through the questions. Michelle just kindly put today's materials in the link so you can download them. Don't worry about looking at them now. We'll share our screen with things that we think are important for purposes of today. But there's a bounty of information in there for you that you will have as a reference, moving forward after we talk about it, that I think will be helpful in your work as a lawyer. So, Sally, for those who have not met Sally before or weren't here yesterday, Sally, you want to give a quick introduction of yourself?
Sure. Work at Smiley & Smiley coming up on 6 years, and I started uniquely. I was a prosecutor for the first 5 years of my career in Brooklyn, and then transitioned during the COVID pandemic. Literally the day before the world ended, I started at Smiley & Smiley and had to learn a new area of law and working in the private sector remotely, and did it through the help of the mentor and some of the other partners at the firm. So, you can do that, and it's been great. So I'm happy to roll up my sleeves and dive into discovery and trial skills. So happy to be here.
All right, let's go. And one of the things that Sally has learned from joining the civil side of practice, from the criminal side of what we do as litigators over the last 6 years, is the importance of discovery. And because there's not a lot of discovery, if any, in criminal matters. So what discovery is exchange of information, finding out information, and building your case. And it's so important that the effort and the preparation that goes into discovery really takes hold, because that's going to shape how your case plays out. And if you're good at what you do during discovery, that's going to get your cases resolved. It'll set it up for motion practice. You could either get summary judgment on behalf of the plaintiff, get the case dismissed on behalf of the defense. If you're defending a case, you could maybe move for indemnification or contribution, and you can shift the liability and compensation from your own client to someone else. This all happens in discovery. So it's a tool for getting information, claim, right? There's a accident case. You need to find out things about the conditions, about notice, all of that. If it's a contract case and you want to find out terms going into the contract, who signed it, who didn't, what's missing. These are the things that happen in discovery. And in addition to making it a fact-finding vehicle, it then allows you to build and craft your case, to posture it either for settlement or for disposition one way or another, or at the end of the day, if the case doesn't resolve either through the courts and motion practice or through settlement, and you have a trial, then what's obtained in discovery is what's going to be your evidence at trial, right? And the witnesses in discovery are going to be your witnesses at trial. And oftentimes, people don't realize the importance of a good deposition or the importance of obtaining and seeking certain discovery until they've tried a case. Because then they're at trial and they're like, oh no, we didn't get this document authenticated, or the witness didn't talk about this, or we didn't ask that question. And now we don't know what's going to happen at the trial. And Sally, maybe you can talk a moment about that, because you had a trial recently and you've done a few trials with our firm, and you got to sort of see, wow, all right, now I see how it plays out, right? After having gone through all the discovery beforehand.
Absolutely. And let me know if the audio is off, because I know there were a couple of comments in the chat saying that the audio wasn't good, but is it good?
I hear you okay.
Okay. So as much as I love discovery, discovery is going to set you up the framework. The investigation you do that we spoke about yesterday during the intake and the investigative process to build your case is then going to help you with ideas to then put in for requests of documents during the discovery exchange. And then that's going to help you make the trial that much smoother. So when you're dealing with the intake and the investigation, that should be raising flags, what witnesses you need, what evidence will help support the case. And then in discovery, you're going to then put in those requests to try and get that information. Just to give you a little info, a tidbit of how this comes to life. We had a slip and fall case outside of a Manhattan building that was a residential building. And the guy was hosing down the sidewalk, as many porters do in the morning, but it was during freezing cold temperatures. And what happens when water freezes? Ice. And what happened? A client fell on the ice and fractured her wrist with having surgery. So what do you want in that discovery? You know a witness, the porter, and now you want to know who trained the porter and if there are any guidelines in training materials. And lo and behold, through my request and discovery, those training materials that we received said no person is to hose down in freezing temperatures. And it was like, well, you had it. So you could see that. And if we needed to take that to trial, it'll be nice and buttoned up throughout the way.
Yeah. So discovery, when you think about discovery, it's what it sounds like. You're discovering stuff. And every party has different things they need to discover, right? Defendant in a case is going to want to discover from the plaintiff what their claims are on liability, what they have to prove damages, what they're going to show at trial. In the civil practice world, there's no surprises allowed at trial. Everyone, since you're newly admitted, you've probably never heard of Perry Mason or Matlock or some of these old trial TV shows where it was, they call in the witness who finally knew the answer, or you're not allowed to have ahas at trial in court. So that's the purpose of discovery, is basically anything that's going to happen at trial has to have come out through discovery. Otherwise, it's really difficult to get something into trial if it hasn't been exchanged, if it hasn't been made available to everybody or developed or elicited in discovery. So there's a lot that needs to go into it. What we have in the materials is some sample discovery demands as a plaintiff's firm that we send out. And every firm should have a traditional set of demands. And what demands are basically asking for answers to questions, asking for production of materials, asking for information, for names of people, last known addresses, whatever it is that you think goes to an element in your case. So, for example, in a typical, let's say an auto accident case, the plaintiff has the burden, right? So the plaintiff is going to need information to prove the negligence of the defendant in the automobile accident. So it could be their cell phone records, it could be video cam footage, it could be passengers in the car, could be witnesses on the street in the police report, lots of information that the plaintiff wants to get to try and prove fault. The defense firm in that case is going to want to try and maybe prove fault on the plaintiff, and same type of information they're going to want to look at that the plaintiff would. But in addition, the defendant will have the burden of their defenses. They have to prove their defenses if they're trying to prove comparative fault, if they want to show a mitigation of damages. In other words, what are the injuries? How's the plaintiff doing? Is there economic loss? Is there medical bills? Are there lost wages? What kind of proof is a plaintiff going to come up with at trial to show what they're entitled to? The defense side needs to explore that so they could either chip away at it and show it's not as big as the plaintiff is saying, or say, look, you have no proof of it. It's the time to show your proof. So what we do as a firm is we'll have our standard demands, which you'll see in the materials for Supreme Court New York civil cases, where it'll be a demand for basic information, witnesses, demand for insurance information, demand for expert information. And those are things that just sort of get the ball rolling. In federal court, the demands are a little bit different that you send out. In federal court, we use following the rules, which you'll have to familiarize yourself with. There's Rule 30, which goes to depositions. There's Rule 33, which goes to interrogatories. There's Rule 34, which goes to production of documents. And I know all these rules off the top of my head because I've been doing this for 30 years, and you'll get familiar with those as well. So there are different tools that you can use. And so whether it's state court, it's CPLR. And if it's in federal court, it's going to be the Federal Rules of Civil Procedure. So as I mentioned yesterday, as lawyers, we have to be rule followers. So you want to make sure that you are complying with the rules with your demand. So any demand you see, if it's in the materials you'll see, it'll say pursuant to CPLR rule so-and-so, please provide the following. It'll say pursuant to federal rule 33, please respond to the following interrogatories, okay? So if you're a new attorney and you join a firm, you're certainly going to want to get access to any what we sort of call boilerplate demands that are sent out generally on all cases. Usually, when an answer is filed by the defense, they'll file it along with their demands for a bill of particulars, demands for authorizations for medical records, demands for witnesses, similar things. So it's really important. Demands for deposition, notices for deposition, where you're going to request who you want to question. You have to serve notice for that type of stuff. So what I would suggest is look through our materials, look at the rules, and also ask within your firm or ask us if you don't find things in the materials, if you want to see samples, because that's a great way to always work off of these samples, and then you tailor them to your specific case. Obviously, demands in a premise liability case are going to be different from demands in an automobile case, which will be different than demands in a medical malpractice case or a construction accident case. So we've been doing this at our firm for so long that we have sets of demands for these different types of cases. So in a construction accident case, we'll always ask for daily progress notes, for site safety meeting records, for contracts between the general contractor and the subcontractor. And so you'll get used to that. But starting off with the paperwork is important. And I'll let Sally talk to you a little bit about what BPs are. Just like yesterday, we talked about PCs and CCs. I guess we like our abbreviations as lawyers. So let's talk about BPs and the importance of a BP, what it's for, why it's something that's always talked about, why they need to be supplemented. Sally, I'll throw that over to you if you don't mind.
Sure. So a BP is a bill of particulars, and basically this is an opportunity for you to reintroduce the case. You're highlighting what the plaintiff's name, any sensitive information about them. You're highlighting the date of the accident, the location, the type of injury, the type of accident, and the negligence or the cause of action that you're claiming. So you kind of spell it out. And then what you do in the BP is you list the injuries, and you would want to order the injuries and place them in the order from the most serious to the least severe, I should say. They're all serious in in nature, but a fracture with surgery is going to be your leading injury. And then, a pain throughout, or numbness and tingling is going to be a lesser of the injuries or the symptoms. And as the client goes through their treatment, what you want to do is then maybe amend or supplement to say, hey, I'm going to supplement this BP because prior, my initial BP didn't have that my client received the surgery. And since the start of this action and the filing or the exchange of this BP, now we have a new injury, now we have a surgery, now I want to supplement the BP to further support and put, essentially on the record in discovery in the exchange of documents, you're putting the defense counsel on notice that there's an addition. So the BP is basically like the next step. The summons and the complaint spells out kind of the legal causes of action, and the BP kind of hones in onto more specific of the liability and the damages and the injuries sustained with other information. Now, the defense may also give you what's called, and we have this as a demand as well on the plaintiff side, is the discovery and inspection. So that's when you either want to inspect the premises, you want to go to a location to see, you would set up questions and information that you're looking for, and then see if defense can provide that, and also look to schedule. I'd like to set up a time to inspect the staircase with my engineer, and you would go with your engineer after getting the specs of the staircase, when it was installed, who installed it, how it was installed, and what materials, or when it was last repaired. So those are things that you want to include in your BP, let alone in your discovery documents to help move the case along.
And you want to think and prepare your discovery demands appropriately for your case. So what we will often do is sit as a firm when our meetings, case meetings, or just, reach out to each other. In the old days, you'd pop into each other's office. Now maybe we'll Zoom or phone call and talk about, we'll say, what do we need? What should we ask for in this case? What do you think would help us prove the case? Yeah, we should see if there's prior incidents. We want to ask for that. Yeah, I think it would be good to go there and do an inspection and bring our expert to take measurements and get photographs, because we're going to want photographs, good ones, of the condition for the time of trial. We're going to need an expert to help us either move for summary judgment or oppose summary judgment. So we want to get our experts involved. And experts can be really big help in the discovery process. We try and get our experts on board as early as possible, whether it's a biomechanical engineer or a mechanical engineer or a physical engineer, someone who can tell you what to look for, what to demand. If you're not familiar with a specific type of case and what you should ask for, then reach out to someone, reach out to Sally and I, and say, I've got a case against New York City, right, whatever it is, like a tree fall case. What do I ask for in discovery?
Sure.
Right? You may not know that you should ask for tree inspection records, that you can go with your arborist, who's a tree expert, to inspect the tree, to look and see for evidence of rotting or indications that it's going to fail. So as I continue to say, litigation is an art, not a science, and you have to decide what you need for your case. And you can get a lot of stuff in discovery. Sometimes you have to push a little bit for it. Sometimes your adversary won't agree to give it to you. Sometimes you'll have to go to court or make a motion to compel. And we spoke a little bit about that yesterday. As a new attorney, you may be the one tasked with filing that motion. So you want the demands to be clear and concise and specific and reasonable. If you ask for records from 25 years ago, that's not so reasonable. You start to learn in practice when you're requesting prior records for anything, whether it's prior medical records, prior inspection, prior maintenance. It'll depend on each fact pattern, but usually talking 3 years, 5 years, more than that can get a little tricky. And it's a practical matter. Who has records going 10 years or more back? Not everybody does. So you want to tailor your demands appropriately. And if you're opposing or responding to a demand, try and give real answers. Many times we'll get responses to our demands that just to every demand says objection, vague, improper, overbroad, improper demand, won't lead to anything discoverable. Literally, it'll say all of those things in one objection and won't provide an answer. And so some firms feel that that's, well, we responded, we objected, but we literally will get responses that provide no discovery. So that will happen, I promise you. And it'll happen both ways. Plaintiffs will sometimes do the same. They'll object to everything and they won't give the defense firm or the carrier information, which I don't understand. You have to give information if you want to get paid, right? If you want to get the case resolved, if you want to make a claim. So try and give detailed answers. If you can't, you could always put in a response that not in our possession, we will supplement. And when you get responses like that, make a note of it so you can follow up with another demand saying, we're following up. Your prior response said you were going to supplement, and we'd like to know if you can supplement that now. And those are also things you can ask about in a deposition. If it hasn't been provided to you through your demands and discovery, when you get a witness, you could ask the witness, hey, do you have access to prior incident reports? Where would we find them? Defense counsel said they couldn't locate any. Can you help us? Who should we ask? What department should it be directed to? Things like that. Solly, I see you're nodding. Something you want to jump in on?
No, I agree with you. I just also think, like we were talking about yesterday, the preservation letter, when you first start on the case, if there's any video, you're asking that company to preserve it. If you're in the insurance stage and they don't want to disclose the video because they don't have to, that's when if you file a lawsuit, that's something you're going to be asking for. Well, you already did the front work, the back work to say, preserve this video. Now you're in a filed lawsuit. Now during discovery, that video I told you to preserve, now I want it. The other thing I would just say is, and I think Andrew is making this point, this is not an opportunity, don't be a stickler. You're not drafting these demands or drafting these responses to these demands for the sake of just checking off a box to do it. It has to be with a purpose. You want to make sure that the information you need or the information you're giving is going to be good, because this is going to move the case along. Good, bad, or the ugly, you decided to take the case. So you have to roll with the information you have, and whether that, creates a room for settlement for a less amount because the case isn't that strong. Well, you turning over the information now or forcing opposing counsel to file motions to compel you to do it is one thing. But if you just get ahead of it, you have to just, walk through the case and handle it the best that you can. So there's no point in just making non-specific demands or responses to those. Get ahead of it, get out in front, and see what happens.
Attendance code number 1 is NEW 129. That's NEW 129.
Yeah, and pick up the phone sometimes. One of the things that, and I'm glad that this program yesterday and today is for newly admitted attorneys, because I want to speak to all of you and share with you some frustration that I've seen in my career over the last probably 15, 20 years, where newer attorneys, younger attorneys feel the need to fight or the need to, be adversarial. Even though we're adversaries, we don't have to treat each other in an adversarial manner. And by that, keep in mind that the person on the other side of the case is just doing their job, just like you're doing your job, right? They've got to respond to and answer to whoever their client is or their boss, just like we all do. And, there's just no need to get pissy with each other, to fight, just to feel like you're fighting, whether it's in paper form or emails or at depositions. I see a lot of lawyers who are just rude to each other. And there's just, in my opinion, no place for that. This is a profession. We should treat each other with courtesy and respect. And we don't have to agree with each other. And there are lots of personalities, and we're going to run into people who are not easy to deal with. Trust me, you've probably been there before, and there are probably some in your own firm, right? But you have to not get baited by it. And this deposition I just came from is a perfect example where the lawyer who was defending his client, who I was questioning, was just, and he knows better. He's not a newly admitted attorney. He's been around, and he was just smirking and making comments and talking objections and things you're not supposed to do. And it's hard. It's hard not to yell and scream. And I'm at fault too. I'll get aggravated. I'll get worked up. Maybe I'll respond back in kind. But we all have to remember to bring it down a notch. And we're representing our client. And just think, what would a judge say to me if the judge was sitting here and listening to this? We've been on the receiving ends of what I like to call snarky emails, which are not appreciated. And Sally and I have had these discussions. We say, don't bite, don't respond snarky or in an obnoxious or tit for tat kind of way. Try and stay above board. And you'd be amazed that like picking up a phone and having a phone conversation or Zooming with your adversary, seeing them as a real person across the way and not just someone who's responding via email and through the e-filing system, will make cases a lot better. I mean, Sally and I go out of our way. We'll reach out to our adversary. Hey, you want to Zoom and just touch base on this case, Or if you get one of these responses that's a non-response and it's all objections, just you can send a letter, of course, but pick up the phone, try and make a good faith attempt, shoot an email, say, hey, can we get on the phone together? Let's see if we can work this out, and it may be easy to work out. And then you may find some common interest. You may be like, oh, you golf, I golf. You play tennis, so do I. Oh, you have kids, so do I. Great. What are you doing? When do you want to get this done? Listen, I don't want to be difficult. I just, I've got a client to represent. I need to put this. I'd like to agree with you, but I kind of can't. Can we figure this out? And that can set the tone moving forward in the litigation. That can make future issues so much easier to deal with. You can be like, oh, I know Andrew. We just spoke already on this case. He's not going to give me a hard time if I need an adjournment. I'm not freaking out. I'll just pick up the phone and call him. You want to start establishing that kind of rapport during the discovery process. And usually the first time to do that, face to face, so to speak, whether Zoom or in person, is usually at the first deposition.
About working with your adversary, the courts want things to be done. You and your adversary figure it out outside of court. The court, will get involved if they need to get involved, but that's why there's good faith letter attempts. That's why picking up the phone and calling your adversary, sending emails and doing it. It's kind of a case within a case. So you do want to build, if defense is really not responding, or you want to then document all of that so you can justify that in a motion to compel. But that is really your last resort, and the court really appreciates that the two parties are really trying to work together to bring this case ultimately to resolution. That is just going to waste time. It's going to involve motion practice. It takes the courts a long time anyway. They're, overworked about getting back to you on a decision on a motion. So now while that time is pending, you're just sitting being like, well, a motion's pending. But yet, if you would have picked up the phone maybe to try and get that discovery or see if it even exists, and if you're entitled to it, it's just a better way to handle it. But if they leave you no choice, then at least you have a documented, detailed list of efforts that you've made, to no avail.
Yeah, it's really important to document. I mean, we just had a case I mentioned yesterday where we got a default judgment and they refused to vacate it, the judge. And the reason why is because our partner, Jason Friedman, did a great job of following up with emails. And he kept emailing defense counsel. Here is our summons a complaint. Make sure you put an answer. Here's a stipulation. Just following up. Haven't heard from you. I really don't want to have to make a motion. Waiting to hear from you. Following up again. And then when you attach all of those to your motion papers, you're boxing in your adversary because they can't say, oh, I didn't know, or I wasn't aware. When you have correspondence where they're acknowledging your emails and it shows it. So try to do it the right way by corresponding phone calls. And again, we talked yesterday about the importance of familiarizing yourself with rules, court rules, individual rules, procedure, judges' rules, and probably hands down, I think Right now, almost all rules require some type of meeting in good faith to resolve a discovery dispute before making any motions for that discovery. So what does that mean? It means picking up the phone. It means sending some emails back and forth. Can we work this out? You said you're not going to respond to my demand and you're objecting to it. What can we work out? Can you give me something? Can we agree to something? And then if the answer is no, then at least you could say, I tried. They wouldn't agree to anything. Unfortunately, we have to make this motion. Because the reality is that motions in state courts, federal court is a little different, but motions in state court for discovery-related issues, just filing the motion, you could sit for months waiting for a decision. And that's just wasted time in the litigation where nothing's happening. And you're just sitting and waiting and waiting. In federal court, one of the benefits of federal court is you don't have those types of discovery delays. If there's an issue, you can write a letter to the judge. Usually 100% you'll have to meet in good faith. And if you can't, you send the letter, you e-file it saying that you met in good faith. You list what the issues are, and the judge will usually set up a quick conference within a week or so. You request a conference, and it's great. You get it with the judge, and they make a ruling right there. So that's what you need to do to try and keep things moving and to keep it collegial. All right, with just about 10 minutes or so before questions, talk about depositions. Yeah, so depositions is one of my topics that I love. If you are an Academy member, which you should be, if you're not, join. You can search the database. I've given lectures for the Academy on depositions. I can spend hours alone on depositions, not just 10 minutes. I will also tell you, as far as helpful resources, which we're always asked about, that I have 2 books on Amazon. You can scan this code next to me right here, and that'll bring you to the page. Sally's got one. One is called How to Successfully Litigate a Personal Injury Case, and the other is Successful Trial Skills. And in the How to Successfully Litigate a Personal Injury Case, you keep it on your desk. There's a whole section on depositions. And I think there's probably even a part of it. Hey, signed one. I'll sign one for anybody. I'm easy and cheap. So the books actually, the proceeds go directly to my charitable causes, which you can find out on the mentoresq.com. And I think they're really helpful. So I direct you to those. There's also some podcast episodes involving depositions. So you can look for those as well. And, but generally speaking, the rule of thumb for depositions is, again, preparation, preparation, preparation. You don't just show up to question a witness without an outline, without a plan, no matter how experienced you are. You have to have a plan of what you need and what you want. And if you're asking a question, there's got to be a reason for it. Don't just ask questions just to ask questions. It has to go to an issue that you're trying to get to the bottom of, to an element of your case that you have to prove, that you have the burden to prove. And there's a difference if it's going to be a lay person or an expert. And I talk about that in my books and my materials, and we should have some of these materials as well. Expert depositions are trickier because they're hired professionals who are used to dodging and not giving you straight answers. So you have to work hard on that. Depositions of lay witnesses who are not hired experts. Maybe they're a witness. Maybe they're just a party to the case, a driver of a car, a witness on the street. Could be an employee of a company. Let's say you're suing Walmart. Someone had a slip and fall in the store, and it's the manager of the store. Those are lay witnesses. They're not going to have any higher level of expertise in battling you and deflecting your questions. They're generally going to be honest, and you just need to be prepared on what you want to ask them. So the takeaway in the little bit of time we have today for depositions is spend your time on preparing an outline. What you want to do is literally make a word outline that you can use when you're Zooming. You can do it. I have an outline, and Sally does, for our presentation from yesterday and today. So I have that up on my screen right now, but you can't even see it, right? It's right under my camera, but I can quickly look down, and it keeps me on track, and it keeps me online. So break it up into parts. When you have a deposition, you generally want to start with someone's background, their educational background, their work background. If they work for a company that's a defendant, you're going to ask their history, what jobs they've held, what their duties are. You're always going to want to ask about their knowledge of the specific happening of an event, their personal knowledge. It could be a records witness. right? Solly the other week had a deposition scheduled to question a witness for the city in a tree fall case. And we went over the areas to ask. And in that situation, it's sort of it's a discovery tool. We're asking these types of people, does the city keep records of this? Which department does it? What are they called? Those types of things. Hey, look at that. Back to basics, preparing and conducting depositions. I know it's there. It's in my CV is part of the materials, and it lists all the lectures I've given. I think I'm up to north of 80 lectures by now, and a lot of them are for the academy, so you can find that. But think about why you have this witness, why you chose to schedule that deposition. Just because the other side produces a witness that they choose, that's okay and that's fine, but you should designate who you want if it's not who they produce. All right. You should decide who you want the witness to be and why you want to question them and serve a deposition notice. If it's a non-party who's not under the control of your adversary, you can subpoena that witness. And there's a method for that to do that. And so you can get a witness to appear, even if they don't have a lawyer. But you have to get these witnesses in. There are some limitations, but none that you really have to be concerned about how many witnesses you can question in a case. You could usually question as many witnesses as you want. And if it gets sort of north of 10, and you really need it, you may have to give proof if your adversary objects and says this is just a fishing expedition. You have to show why. But if it's a big case with a lot of people involved and you have to get to the bottom of it, take their deposition. Couple things, just sort of pointers. There's stipulations. At the beginning of each deposition, the court reporter is going to say usual stips. Usually everybody says yes. There's usual stips in state court, in federal court. We've given you samples of that in the materials. And I suggest you read them. Most people don't read the stips, even though they agree to them. Just today, this obstructive attorney that I was talking about at the beginning, get this. The court reporter said, usual stips, everyone, right? All of us, yes, 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 yes. And the one defending the witness, he goes, well, I'll agree to them except for where I feel that they shouldn't apply. What is that? You can't say that. You're either agreeing to the steps or you're not, and you're saying what you don't agree to in the usual steps. But one of the things in the usual steps is you're not directing witnesses not to answer, that all objections are preserved. So if you find yourself in a situation which I did as a new lawyer, where I was questioning in a medical malpractice case, and there were several defendants in hospitals. And so it was me against a bunch of very senior and experienced medical malpractice defense lawyers. They were objecting to my questions left and right, and they were sort of beating me up a little bit. And I think I did a pretty good job. I kept my cool. And that's what you have to do. But you have to know what the rules of engagement are. So if a lawyer starts saying, Mr. Solomon, you shouldn't be asking those questions. Those aren't appropriate. And they start, talking down to you, which you will likely experience at some point as a newer attorney. You just respectfully say, counsel, I'm aware of what I can and can't do. I'm aware of what the stipulations state. I'd appreciate if you don't lecture me or give speaking objections because that's not permitted, the rules. And I'll just continue. If you have an objection, I'd ask that you please make it a succinct objection on the record. Speaking objections are not allowed, which means they ask my client, what time did you get up today? I can't jump in and be, counselor, that doesn't matter what time they got up. Why are you asking all these questions? That doesn't matter. Move on to your next question. That's not allowed, okay? All I can say is, objection. I could give the basis or not, and then I have to let the witness answer. All right. The only time that you are permitted to direct a witness in federal or state court not to answer is to preserve a privilege. Okay. Marital privilege, attorney-client privilege, Fifth Amendment, right not to self-incriminate. So you can direct a witness not to answer if it's to protect a privilege. Other than that, it's got to be, clearly harassment and out of left field. All right. Although many lawyers will say, you're harassing my client. You have no reason to ask that question. It's got to be really, really, really bad and really totally far-fetched. You're allowed to ask what you want in discovery. That's what discovery is for. Just because you ask it in discovery at a deposition, just because your witness answers it as a deposition, doesn't mean it comes in at trial. Things are discoverable that are not going to be allowed into evidence if you can establish it. I'll give you a great example. If they ask your client, have they ever been arrested for anything? That can be asked at a deposition, but can you ask that at trial? No, you can't. Okay. At trial, it's very specific of what can come in as far as it has to be a conviction. It depends on the type of conviction. It depends on whether it's a felony. So there are lots of things that you may not like that your client has to bring out at a deposition, but that's what you need to prepare them for. And I talk in my book and in the CLEs about how to prepare your clients, but you need to find out if they got anything you've got to worry about before they're questioned. You don't want to be sitting there when the lawyer asks your client, have you ever been convicted of a crime? And your client's sitting there and looking at you and hemming and hawing. That's not a good feeling. So when you're prepping your client, you're going to say, I just got to ask you, I don't want any surprises. You ever been convicted of a crime? Or do you owe child support? Have you ever filed for bankruptcy? Any skeletons in your closet that I need to know about? Because it's confidential with me, and I'll prepare you on how to handle it at a deposition. But don't hold back from me, because if they ask you at a deposition, I want to be in the best place to protect you. And so I need to know these things. All right. You'd be surprised. The church going nice old lady, she may have been a delinquent back in the day, right? Before she found God. So don't assume anything. All right. So those are just some brief pointers. I know we didn't do a lot on depositions today. We've got so much to go through, but I do encourage you to look at my other lectures or the books. Sally, I'll give you the last word on depositions before we go to some Q&A to wrap up this hour.
Sure, and there's some good questions that we can help round out the discussion, but to maybe touch on a few that will help. So as Andrew was saying, if the only time that an attorney can object is if it infringes on privilege, if it'll inculpate a co-defendant, or if it's palpably irrelevant. So someone had asked, what do you do if an attorney instructs a client not to answer during a deposition? Well, if it falls into one of those three categories where they can in fact make a proper objection to block the question, sure. If it does not, I would do the first step of reminding the attorney that it doesn't fall into any of these three categories. Maybe ask the attorney why they think that it does fall into one of those three. And the next step is to say, hey, I think we need to take a timeout. Let's call the judge. Let's call chambers. Let's see if the judge can make an immediate ruling. State court might not be so easy to do so, to get the judge on the phone. Federal court, they may be willing to, but maybe also say, figure it out. You can preserve the objection, or you can preserve this and make a note for a further ruling. And then you can take that deposition and use it as part of a motion or part of your argument. So that's a way in which you can handle it. And then the last thing in terms of structuring for your own client's deposition, there was something about how do you prepare your own witness. What I like to do is the 3-chapter method. Just say you're going to be asked, think of 3 chapters. So when you hear the first chapter, it's going to be all about your family, your background, which is what Andrew touched upon. The second chapter is going to be about, now I want to talk to you about the date of the accident. So when you start hearing those questions, you're going to know we're on liability. And then the third chapter is going to be damages. So when you hear, I tell the witness, my client, when you hear the question start to go, now from the scene, did you leave by an ambulance? That's when you know you're in damages, chapter 3, and they're going to talk to you all about the injuries, the treatment, and the symptoms you still currently have. And then I always go over with the clients these 2 questions. One is, what were you able to do prior to the accident that you could still do with difficulty? And what were you able to do prior to the accident that you can no longer do? So if the client is able to answer those questions, those are generally questions that the defense asks. The other thing about prepping the witness during a deposition, you want to just spell it out for them. We're going to be on a Zoom, or we're going to be in person. It's going to be me. It's going to be the defense attorney. It's going to be the court reporter and you, and they're going to type down everything you say. And if you need to take a break at any time, it has to be after a question is asked and answered. You hit them with those ground rules so that when they come into the deposition, even though it may be foreign, it's not that foreign to them. So
great points. Great points. All right. Let's get to some questions, right?
Yeah, go for it.
All right. So I'm going to start off with Yandy. Yandy is saying, what's been our experience when parties aren't responding to bill particulars or bill particulars as to affirmative defenses? Is there any way to leverage their failure to respond and give more details, showing lack of liability or damages? It's as we spoke of before, Yandy, if you're not getting proper answers to a discovery demand, which covers demand for bill of particulars, bill of particulars as to affirmative defenses, for those who are not sure what that means. If you're a plaintiff and the defense and their answer has affirmative defenses such as comparative fault, failure to mitigate their damages, and the like, you as a plaintiff can serve a demand for a bill of particulars as to their affirmative defenses. What are they basing that on? What are they basing comparative fault on? What are they basing the lack of mitigation of damages on? And you do have the right to do that. And oftentimes you get a boilerplate or not a real response. Same thing with others. If it's something that you're really just not getting and you think it's worthwhile, call up the lawyer, email the lawyer, ask if they could give you more specific responses. If not, you've met in good faith, and then you have to make your motion. Okay.
Great. There's another one. Ellen, it says, in a slip and fall, if you think there's a video and you make a demand for it, what is a reasonable time frame for them to turn it over? If they say there's no video, do you take their word? Look, it's tough. Is there a reasonable time? I think when you make your demand, usually it says must respond within 20 or 30 days. If they're not responding thereafter, first you want to establish if there is, in fact, a video, if you did have that preservation, language in your initial part. But if they're saying there's no video, look, there's a level of trust. We're officers of the court. You would hope that everyone in the profession is truthful and honest. And if that video, it doesn't exist, then you have to take their word for it. If you make the efforts with your investigators to find out if there was video or that it did even exist, we've had some cases where, it seems like video is unavailable, but yet it seems so clear that there should have been video. But you take it as you may, you roll with the punches, and that's what makes every case different. But at the same time, you have to take their word.
And as for videos, that's something that you can further explore in depositions or at a DNI. So if someone slipped and fell at someone's place of business and they say, oh no, there's no video, you can do a DNI and look around. Do you see cameras? Right? And then you call the lawyer up or you tell the lawyer right there at the inspection, there's cameras. You said there's no video. Well, we asked, they said there wasn't any. All right, I want an affidavit from somebody saying they checked and there's nothing recorded. You could also ask in depositions of a party, if it's the parties that's saying that they don't have any video, do you record video? Do you have any video cameras on property? Where are they located? Why do you have them? So you can dial down a little bit more to try and feel comfortable about whether or not they're being honest with you. Okay. Tatiana, I love that you always ask a lot of really great questions between yesterday and today. Thank you for this one. It's a great question. How would you deal with a client who considers a friendly interaction with an adversary attorney as a conspiracy against your own client? And the reason I love that question is that many lawyers, newly admitted or otherwise, feel like unless they act tough, unless they're mean, unless they show they're aggressive and fight, then their client isn't going to think they're fighting for them. And it just can't be more far from the truth. Anyone who knows me or Solly or has interacted with me in the last 30 plus years or Solly in the last 10 plus years since he's been a lawyer, they know we're nice guys. We just are. And for us to be nasty would be very out of character. And unwarranted, and there's just no need to. So, I always tell my clients before a deposition, listen, I don't fight. I don't make a stink. The rules are the rules. They're allowed to ask pretty much everything. If I object, I have something I call the hand trick, which you'll learn about if you read my book or listen to the other CLEs, where I tell my client in a deposition, if I put my hand up in front of you, right? Or if you see me do this on Zoom, consider it like a gate at a train track. There's no passing. There's no talking. You don't say a word. The minute you see my hand go up, you shut it down. Let me handle it at that point. I'll make my objection. And then when I put the hand down, I'll give you instructions to answer or not. It's called the hand rule. It works great. I actually stole this off of one of those older, experienced medical malpractice defense lawyers who was beating me up when I was questioning his witness. He kept throwing up the hand, and it drove me crazy. But there's nothing wrong with doing that. There's nothing wrong with doing that. So I tell my clients, listen, I'm not going to be abusive, unless there's a real reason to. I'll push back respectfully. So, if you want to be one of those people that, I see these ads on the subways for like bulldog attorneys and take no prisoners. And look, it goes back to screening cases. We talked about that yesterday. If someone's looking to get a lawyer who's going to be a jerk and make somebody else's life as difficult as possible on the other side, we got to tell them that's not us. I'm sorry. That's not our job. Our job is to not be a jerk and make someone's life difficult because they're our adversary. Our job is to get a good result for you. And there's that expression, right? You're better off getting something with honey and being kind and nice. And I can't tell you how many adjusters I've settled cases with over the years, claims representatives, at the end of it, and they say, thank you, Andrew. You've been such a pleasure to deal with. You're actually nice. And I say, what do you mean? Other lawyers haven't been nice to you? And they're like, you'd be amazed how rude plaintiffs' lawyers are. They yell at me. They scream at me. And I scratch my bald head and I say, why would you yell and be mean to somebody that you're asking money from? It doesn't make any sense to me. It still doesn't. So, Tatiana, this is my long answer to your question of you tell your client that I have a good reputation. Being kind and sweet is a great way to get what we need. And don't be fooled. Don't change my sweetness and kindness with lack of my strength in litigation and ability to get results. Okay? And Sally's a perfect example of that. He's the same way. He's the nicest, kindest person, a great adversary. He has great interactions with insurance adjusters. That's why we call him Settlement Sally. And he gets settlements because he establishes a rapport. And it's really important then that you do that in your litigation with the claims representative, with defense counsel. If you're a claims representative or your defense counsel, reach out to the plaintiff's lawyer, establish a rapport. We all have some flexibility, right? And, we can all help each other out wherever it is. So I think that's super, super important to do that.
Yeah, I think also it's great points. And the next two go hand in hand, Yitzhak and then Elizabeth. Yitzhak says, don't some attorneys thrive on motion practice in order to build the clients? I've heard this from some of my colleagues. And Elizabeth says, can you speak more to dealing with overly burdensome discovery requests and how have you handled settings where the adversary is fishing before moving the court for intervention? Could be one and the same. I wouldn't read too much into it if attorneys are going to bill. Look, attorneys need to do what they need to do on the defense side. They need boxes to check. They need to do things on their end. If you think that they're billing, look, I never have an issue of getting right to it with the attorney and saying, hey, is this a case you got to bill on? I'm happy to make sure you get all the time in the world, but I'd also like to move this along. And, they'll laugh and be like, no, I'm in-house. I don't need to bill on this. Or, no, I'm okay with my hours. So you drop that funny line. It kind of lightens the mood and you keep it moving. But look, they're going to play their game and you're kind of at their mercy because if someone from our firm says, we're not the ones that write the check. So you got to play the game. You got to move the ball down the field every step that you can and do the best you can. And then with overly burdensome discovery requests, look, if there's things in there that are, not relevant, then you say, not relevant, not going to be provided. And if they push back, then you can make your arguments back to them. Or that's where I pick up the phone and say, what's with all these requests? What do you really need? What can I do for you? I'm an open book with my client. If I'm happy to give this to you if we have it, but if we don't, then can you just stop? So that's really for you. And that's where you develop your own style and your own personality of how you want to engage with your adversaries. And again, like Andrew said, it doesn't have to be adversarial. It doesn't have to be rude, aggressive, unprofessional, but you can figure out what they need. And if you work together, it kind of makes the case go by a lot quicker.
Yeah, just to touch on that issue, because it does come up a lot about billables and milking a file or working a file. I have a lot of friends who practice on the defense side, who manage defense firms. And just to be clear, it's unethical to just bill for the sake of billing or do work just to get paid if it's not necessary or needed. All right, so let's just put that out there clearly. Most attorneys will tell you that They bill for the work they do. They do what they need to do. But any firm or attorney that's got a decent client, that client is going to want to get the case resolved ultimately. That's why they're hiring you to defend the case. And I have many, many friends on the defense side who say, listen, don't worry about my billing. I got plenty of work to do. My clients like to get cases resolved. So we have a whole part of our firm that's a billable basis, our insurance coverage practice, and we bill clients, but they don't bill to just bill. They bill for the work that has to be done. And that's how it should be. Now, does that mean that there aren't lawyers out there that are just filing extra letters and filing things? And so, yeah, there are a lot of times that we'll look at each other and be like, oh, I guess they're trying to bill this file. There's no need. You don't need to file this. You don't need to send this. You could have picked up a phone. And that's going to happen. But look, if you're thinking that that's happening to you, or if you're one of those people that are like, look, I'm a young lawyer, I'm going to get fired if I don't get my billables up, I've got to do it. You know what? Still have those conversations with your adversary and say, look, you're going to see a lot of filings coming down the pike. All right. It doesn't mean that I don't want to work with you. It doesn't mean that I'm not going to get you what you want. It doesn't mean that we can't get this matter resolved. There's just things I have to do. Okay. I have to make this motion. I have to file it. I'm sorry. You can always put that barrier up. You can always blame your boss. I always tell Sally when I'm like, Sally, you got to file this motion. These people are driving us crazy. They're dragging. And Sally will be like, look, but I have a really good rapport with them. We're trying to work towards resolution. I don't want to just file a motion. And I'll say, look, how do we preserve both? How do we aggressively pursue our case for our client, but also not upset our adversaries? Well, blame it on me. And Sally can. He could say, listen, guys, I'm trying to resolve this, but Andrew's telling me you got to file a motion. I'm sorry. It's coming down the pike. And that's okay too. And people usually understand that. All right. All right. Let's go to, all right. Joshua is asking, if it takes months to get a decision on a discovery motion, do I think this serves as incentive for opposing counsel not to hand over discovery? The longer the case goes on, the more plaintiff has to wait for his money. It sort of falls into the same category. I don't think it's incentive. I think that's bad lawyering. I think it's unethical. You don't hold stuff back purposely to delay a case. Are there times that we're at mediation and they say, listen, they'll pay you $10 now, even though the case is worth 15, because it's going to take 2 years to come to trial. So if they want to wait 2 years, they can. You know how it goes in this county once you file a note of issue, or they could take the 10 now and have use of the money. I mean, that's sort of a similar argument. Clients don't want to have to wait. So there's nothing wrong with using that argument, and that argument makes sense. And we say to our clients all the time, yeah, you may get more, but wouldn't you rather have money now and money in hand? That's different than purposely using delay tactics. Does it happen? Look, it's going to happen. You're going to get firms that litigate in different ways. Not everybody litigates above board or as professional as we'd like them to. Our goal, by having 700 of you here today and yesterday as newly admitted attorneys, is to try and set things right at the outset, to have you all practicing. So when you get to 30 years from now, like I am, you'll be like, yeah, that guy Smiley told me, that it's probably best to do it this way. And I found that to be the case and sort of pass it forward. So Josh, hopefully that answers your question.
Attendance code number 2 is NEW 232. That's NEW 232.
All right. Jackie, any tips on questioning expert witnesses like IME examiners, treating providers? Yeah, lots of tips. Look at that CLE I did. Look at my book. I did a recent CLE on questioning experts for the Academy. Usually when you're questioning doctors, it's probably going to be in a federal case. Expert depositions are not permitted in state court cases, but they are in federal court cases. So I did do a CLE very recently, I think earlier this year, where I talked about questioning experts in federal litigation cases. I give samples, I give a lot of pointers. So I defer you to that. It's too much to take up the time with today, unfortunately. KG, how you doing? Did we call the judge today? Because sometimes you have to. Yeah, that's how I left it. I literally was like, guys, I got a jet. And my partner Jason's on it, and some other lawyers. They're like, "We're getting the judge on the phone now," so I have no idea what's going on. I think that deposition is going to be going on all day today, and hopefully the judge will get involved and all that. But yeah, as Sally said, always have the name of your judge and the phone number for chambers and for the courtroom when you walk into a deposition. Always, always.
And that's why saving those judges' rules, like we said yesterday, will come in handy. You pull it up immediately. You have the chamber's number. You're ready to go. That is part of preparation, is having everything at your disposal so that if you need it, it's an insurance policy. If you have it, you need it, it's there. If you don't need it, but you have it, at least you feel safe. So
yeah,
very important.
I generally, if it's something that I really want an answer to, I won't mark it for a ruling and leave it. I'll mark it for a ruling. I'll mark each thing for a ruling. And then at a break, I'll tell the lawyer, I'll say, listen, I'm getting the judge on the line because you're not allowed to direct this witness not to answer. It's clear in the rules. It's clear I've got the judge's rules here. So I'm going to give you the opportunity now to reconsider, and I hope you will, and allow the witness, and we can have the court reporter read back the questions that you wouldn't let me ask. Otherwise, let's get the judge on the line. And then do it. It's not a bluff. Sit there, you put your phone, you take your cell phone, you put it on speaker, you call the judge's part. Hi, yes, we're hoping to get a ruling. We're on this case before Judge so-and-so. The witness has been directed not to answer. And if they get the judge, they get the judge. Sometimes they get the law secretary who will say, no, you're not allowed to continue on. And so probably at least half the time I'll get the lawyer to reconsider before I get the judge on the line. And we usually work it out. So I would encourage you to do that. Again, Mukadas is asking if the opposing counsel keeps answering for the client or interrupting, you got to put a stop to it. You just got to say, counsel, you can't do this. You can't per the rules. Either stop it right now or we're going to get the judge on the phone. You get the judge on the phone. Do not allow yourself to get bullied. Never, ever in a deposition. I don't care if you just got admitted last week and you're at a deposition with 5 other lawyers who have been doing it for 30 years and they're telling you what to do. Do not get bullied. You stay focused on your outline, on what you need to get. And if they're obstructing you, then you get the judge on the line. Go ahead, Sally.
Yeah, and just as, and I think maybe we should move on to the next hour. But just as a last, guiding principle, if you just take the ego out and you don't worry about, anything else or the optics, there's nothing wrong with saying, I need to take a quick break. You pause your video if it's virtual, you mute your audio, and you call your colleague or you call, your boss, or I'm constantly, look, I'm not asking a question, getting the answer, then not sure how to handle it, and I got to call. You have to have some skills and you have to have some flow to the deposition. But there's many a times where I'll take a timeout on the field, I'll pause and mute. I'll go over, hey, Andrew, this is what they said. This is what we're looking to elicit. The defense is pushing back on this. And Andrew will say, okay, based on what you're telling me, go push back on this. Tell him you'll get the judge on the line. Tell him this, tell him that, and see what happens. And, stay in your position, stay firm, and blah, blah, blah. And that's what it is. Time back in. I have my thoughts. I've recollected myself, and there's no issue. And as Andrew's going to tell you, like in trial with the picking up the water trick, no one knows, no one needs to know, and no one cares. This is about you and getting the job done for your case and your client. And if your boss is going to think less of you because you took a timeout and called him during a deposition, then that shows a lot about the boss or the supervisor that's supervising you. I don't think that any colleague would have an issue with that. And especially as the man whose name is on the wall and he's the mentor, he's more than ready to answer that call when I'm in a deposition to say, here's what I think you should do.
And you all can reach out to me too. I make that offer to everybody, whether they're my mentorship program or not. If you're in court, if you run into a situation that you're not sure what to do and you have nobody to ask, reach out to our office, just Google our name or whatever. You'll get a phone number, you'll get someone, and just say, I'm one of his, mentorship people, or I've been in his CLEs, I'm in a jam. Can he call me? And I'll be happy to call you and help if I can. All right. I want to just stress two more points in the questions,
yeah, sure.
And then we're going to talk about trial skills. Now that Sally told you about my water trick, I'm going to have to make sure to incorporate that. All right. So Diara says that I've heard that an attorney must never apologize. How true or not is that advice? And then Hassan talks about an apology she heard. So it really annoys me when I hear these like I don't know what you call them, but these sort of commandments that come down that lawyers give. Always do this, never do that. I mean, where in life does anybody say things like that? I totally disagree. And you should absolutely apologize if you've done something wrong. Absolutely. And there's nothing wrong with that. It shows strength, not weakness. If you do something, people make mistakes. I'm sorry. Okay. I mean, I had a deposition in a case last week. It was a federal case, and it was a Rule 30b-6, which is where in federal court you are asking the defendant, that's a corporation or a company, to produce somebody for a deposition to answer on a bunch of topics that you have on that notice. Okay. And while I was asking questions, the lawyer, who's a very decent guy, he said, I'm just going to object. This was not in your Rule 30b-6 notice. I think it's outside the scope of what you're asking when you're getting into this area. And I pointed out, I said, counsel, please look at page 6 or number 6 that covers this area. And he looked at it and he was like, oh, my apologies. I missed that. Okay, no problem. Go ahead. What's he supposed to say? I'm not apologizing, or this, apologizing is certainly fine. Conceding things are certainly fine. Think about it this way. Your reputation and your credibility, not your firm. If it's your firm, it does. But everybody, myself, Sally, our reputations are going to follow us. Believe me, your reputation is going to follow you. You may not be thinking about it now as a newly admitted attorney, but wait till you've been practicing 20, 30 plus years, 40 years, 50 years. And people are like, oh, that person was a jerk. I remember them from a deposition I did. Or, oh, that person was so decent. I remember they something came up. They didn't even owe me an apology, and they did. So just remember that the way you handle yourself and all of these things that we do is your reputation. And reputation matters as a practicing attorney, because that's how you get business. That's how you get respect from your adversaries. That's how you get respect from judges. That's how you get good results. So I'll leave it on that note, and then we'll get into trial skills. We ready to do it?
Let's do it.
All right.